Well, obviously, as a law student, any discussions about legal education and public international law are of interest to me. And it seems that the discussions regarding public international law will continue to surround discussions of norms, competing norms, defining norms, finding norms. And in some respects, I think this symposium in and of itself reflects that, where we only had one panel that spoke on some of the empirical evidence coming out of Northern Ireland. And it seems to me that legal education and public international law is lacking a sort of empirical basis. Am I just out of my mind, or is there things that we can do to try to bring back, so I guess, a little bit of social science behind the law and behind the discussion of norms?
Well, when I teach international law, I always say that international law, one of the fascinating things about international law, it's about half law and half politics. And I think it does reflect international norms. I think there's a lot of empirical knowledge out there that really drives the international norms. I don't think it's simply pie in the sky. International law usually gets a bad name only when it fails in conflict management situations. The world would not function without international law, public international law. It would not function without private international law, international business transactions. So I think there's a lot of empirical experience out there that dictates that international law is very real. The rights of international law are very real. So I don't think it's so much a shortcoming on the part of international law and the international experience that drives international law. There is a school of thought that's been touched upon in the United States right now, largely set forth by the Federalist Society and other folks who have the same views, that unless it's federal law, it simply doesn't count. I think it's one of the reasons that the Supreme Court got it wrong in Hamdan when it said that Article 3.1c applies to Al-Qaeda. I would have wished that they would have said that the principles of Article 3.1c apply as a matter of customary international law without having to turn non-international conflict into some kind of transnational conflict, because I think that's bad legal reasoning. But I think that they didn't want to do it because the court felt that unless it was treaty law, or it couldn't be enforced in federal courts. If it was customary international law, that's not enforceable in federal courts, and that's one of the problems associated with that particular concept. But I think there's a lot of empirical information and knowledge out there that drives home the point that international law is very relevant and very real.
Just briefly on that, we've had this big wave of movement in the U.S. in legal scholarship toward empiricism, and I'm nervous about that. I think that we're trying to mimic methods used in economics that political scientists have adopted. The economists are backpedaling from it very quickly and are much more sophisticated in what they're doing now, and the political scientists have really painted themselves into a corner, and I'm sorry to see that some lawyers are following in that path. I think it's got limited survey data, yes, but to try to do some of the quantitative assessment of law is, I think, very problematic, especially for international law, because of the number of variables you have to take into account. The book, The Limits of International Law, by Eric Posner and Jack Goldsmith, a writer of one of the most reprehensible of the memoranda, the one that said we could send persons protected under the Fourth Geneva Convention out of Iraq into secret detention. He wrote The Limits of International Law right after he left the Bush administration. The timing, I think, is noteworthy. And he tries to use a rational choice methodology, which I find so incredibly flawed, that I had to, of course, use rational choice methodology in my book to respond to him. It was very painful, but I did it. So, it's not that we want to not take any account of social science methodology and new developments, but I think our field is so complex and so much better subject to our observation than to trying to reduce it to formulas. So that's what I would urge, to be open-minded, of course, and to move this field that we need so much forward as best we can. But I would just say, in response to Philippe's a view that we don't have to really worry about these folks from the Federalist Society that David just described to us. Our Chief Justice of the Supreme Court is a very young man who holds these views quite firmly, that international law is not important law when we decided it's not, but very important when we decide that it is. And I find that a very troubling perspective from the chief judge of this country. So I'm not as sanguine as Philippe. I think we're going to need to put in our briefs to inform our students, to write the kind of articles that can create a broad and general new information program in this country to respond to the very heavy damage I think that's been done since the 1960s.